Okay, everyone, thank you very much. This is our second panel on our Reimagining Tax Administration series of workshops, where we have, today we are covering what I call the 3 A's: audits, appeals, and adjudication. And we have a great panel coming up that just all sorts of different perspectives and information from different states and different types of taxes, and tax procedures that relate to the review of state assessments of tax. Just a few housekeeping items. This program is being recorded. We do ask that you keep yourselves muted. Each panelist will make a presentation, but there'll be plenty of room for discussion. And during the presentations, please feel free to use the chat to ask questions, make comments, share information about your state's practices, because this is something about state tax practices. And then, Les, the moderator, will incorporate your questions and ask that, or you might have a chance at the end to be able to enter into the discussion. We've got enough time to be able to do that. I will put in the chat shortly the link to the materials, all of the PowerPoints. There are outlines. There are other materials available on that webpage. And we will be posting a video of this session as well. And you as registrants will have that opportunity. So if there are materials that you want to go back over, you can do that. And then ultimately that page will be made available to the entire public. As you know, this project has been funded by the Rockefeller Foundation, and we're really grateful to that. And we are conducting a nationwide survey of state taxpayer rights that Anna Gooch, the Public Service Festival, the Festival Fellow, is doing throughout last year and this year as well. And without any more introductory information, I'm going to turn this over to Les Book, who is a professor of Villanova at Villanova Law School, and he's also a member of the board of directors for the Center for Taxpayer Rights, and the co-founder of Procedurally Taxing and the author of the major treatise on federal tax practice and procedure. So Les, take it away.
Thanks so much, Nina, and thanks to the Rockefeller Foundation for supporting this important project. And I'm just thrilled to be here today and introduce really an all-star panel with differing perspectives and experience that I think will inform the discussion and hopefully begin a conversation with folks who are here today. And we have some top practitioners. We have Craig Bell, who is a partner at McGuireWoods in Virginia, who's an adjunct professor at William and Mary, has been a leader in the Virginia State Bar, and has been active throughout his career in issues with respect to state tax, and has extreme understanding of practical experience with engaging with clients before all aspects of administrative appeals and audits and through to judicial disputes. We have an additional practitioner perspective from Larry Hess, who is a solo practitioner based in New Mexico. And Larry has extensive experience in audit and collection matters, and will share a perspective looking at a unique tax, but has in New Mexico a gross receipts tax, but will provide really a platform for discussion for a number of topics. And then we'll also hear today from Christopher Meislahn, who is the taxpayer rights advocate in the New York State Department of Taxation and Finance. And Chris has worked for over 12 years had worked for over 12 years in the audit division, and has extensive knowledge of the audit and appeals process. And we'll be able to learn from Chris's wide experience, both in audit appeals and also in Chris's role as taxpayer rights advocate. And we're also really fortunate today to have presiding New Jersey Tax Court Judge Meislahn, who was appointed to the New Jersey Tax Court by Governor Chris Christie back in 2009 and was reappointed in 2016 and a couple of years ago was named presiding tax court judge. And Prior to her time on the bench, Judge Sundar was at the New Jersey Division of Law and was a Deputy Attorney General and represented state and governmental agencies on all taxation-related issues. We also are joined today by my Villanova colleague, Professor Mike Sems, who is a professor of practice in the graduate tax program. And Mike has had extensive experience in government. He was Governor Ridge's chief tax counsel. He also has been a partner at big law firms and at 2 Big 4 accounting firms. So Mike's experience is really broad and deep. So this is a great panel, and we're really excited to hear what our experts have to say and engage in discussion. So we'll start with Craig, who will kick us off today.
Great. Thank you, Les. Hello, everybody. Good morning or good afternoon, depending on your location. I am not a slide person, so you will not have any PowerPoint slides, but I don't want you to feel lonely. I have put together 4 separate outlines which are being or have been made available to you. And I think they're not too much comprehensive, but it's 50 pages or so, which means you don't really have to take a lot of notes. You hopefully can just listen. Don't be bashful with questions, though I understand, Les, you're monitoring the chat, so I'll probably just be looking at the screen and every once in a while see a little number there and hope someone looks at it. So I don't have a lot of time because we have a full slate of panel members. So I want to mention 2 outlines. I'm going to set them aside, but I want to tell you what they're there and I'm recommending to you. The first one, I'll just read the name of the outline. So if you want to access it, you can. It's called Handling a Tax Audit, Managing the Information Process. And this is kind of my 10 best hits list of mostly what I would consider common sense, but really working with our clients to prepare them for the audit and also for the possible administrative appeal or judicial challenge. So in other words, really getting yourself fully implemented with the facts, the legal issues, and all those things before the auditor shows up at your door. Most clients, from my business clients, they get it. From my individual families, family offices, they don't always get it. They just kind of say, do I really have to do this? Can I ignore it? So anyway, there's a 2-pager. I would recommend you look at it. The other outline, and I'm not going to cover too much of it because it's just a special type of tax, is real estate tax challenges. I do a lot of it. I'm licensed in a number of states. I'm going to be talking about Virginia's today. And Virginia's real estate tax has a whole separate procedure from just about any other business tax, sales tax, income tax, you name it. And I thought it would be better just to give you something that talks about statute of limitations, extending statutes if you want to go that route. Your administrative rights, who do you go to? It's different than all the other taxes. Judicial applications, all the presumptions of correctness, the burdens of proof, shifting burdens of proof. What is fair market value in Virginia? It's a little bit different. It's actually the same as with when we do federal tax, but there are other states that talk about market value. And in Virginia, it's fair market value. And that's a critical mistake. And it's fair market value as of a particular date. We call that tax day. For most jurisdictions, we have 158 in Virginia. It's going to be January 1st, but there are a number that use the alternate date of July 1, which is the start of our fiscal year in Virginia. And that leads to confusion because you could have July 1 for real estate and you could have January 1 for tangible personal property, machinery, and tools. And so if you are not a regular practitioner in Virginia, mistakes can be made. So that's why I thought it'd be better just to give you the outline, look at it. You can always shoot emails to me later, or if you have questions, I'll try to do my best. So what I'd like to do now is go into my outline called Virginia Procedure. And again, I'm just going to do a very high level. You've got a decent there. The first thing you need to do, and this is fairly common sense, I suspect, in all states, is you have to figure out who is the agency or which agency is administering the tax. So in Virginia, at the state level, we have three tax jurisdictions: the Virginia Department of Taxation, our State Corporation Commission, and our Division of Motor Vehicles. They all have their own rules and requirements for audits, appeals, and adjudication in court. And then we have local taxes, and in Virginia, depending on the jurisdiction, it will either have a commissioner of revenue, which is a constitutional officer elected by the residents of that county, or a director of finance. And you might say, why is there two? It depends on how that local government has formed itself for managing the jurisdiction, and depending on which method they go is what you have the rights for. I want to talk initially about the tax department, because generally that's at state level, that's going to cover most of your taxes, corporate income, individual, sales and use. And then we have things like egg tax, peanut tax, and we are an agrarian state, so they all have their own separate rules. They also all have their own separate statute of limitations. Unlike the federal system, when we're talking with excise taxes and income taxes, where you say, well, generally it's 3-year statute from the due date of the return, unless extended. In Virginia, you have to look at the tax, and the taxes will have different statute of limitations. So for example, a sales tax, well, every monthly return is a separate return, and you have to calculate that statute for each return. It's generally going to be 3 years from the last day of that month. However, what happens if you don't file? Unlike the federal system, where you may not have a statute of limitations that begins, Virginia will usually carve out and say it's a 5-year statute or a 6-year statute if you haven't filed a return. Again, it's addressed in the outline. And you get that. So I guess my message to the practitioner out there is you really need to look at this stuff first before you file anything with the local or state government, depending on what your tax is. What if you're asked to waive the statute, extend it? Personally, I'm not a big fan of extending statute of limitations. Because I'm in the private sector, I'm zealously representing my client. There has to be a benefit to my client to justify a waiver. And the way I judge that is if I've been participating in the audit, we've been producing documents, and as the government is going through them, they're narrowing the issues or they're comfortable with certain aspects. In other words, there's a cooperation going on there. Then in those cases, I will consider a waiver as long as we're able to continue that process. Where I don't recommend it to my client is if we keep giving documents and they keep coming back with more questions on the same issue, I advise my client, why are you going to give them more time to build a better case? We're better off letting that statute go. You're going to get assessed regardless. And so we'll just take it to the next level. So the key thing, just like with federal, is if you're going to do a waiver, it has to be in writing, has to be an authorized person, and it must be signed by both parties before that statute extends. If the statute extends, you cannot bring it back to life. A couple other things in Virginia, we do have offers in compromise, similar to what we have with the federal system, except lacking all the regulatory guidance one would hope to have, which is a common problem in Virginia. Virginia is not a firm fan of regulations. And for my business clients, we like regulations. My clients want to be in compliance. And unfortunately, it takes 2 to 3 years under the best of circumstances for regs to be approved. And the State Department decided they're going to sidestep the Administrative Procedures Act, which is the way a regulation is created with notice and comments and all that. And they've chosen to issue something called guidelines. They look just like regulations. Here's the problem. No public notice. Sometimes they'll ask you a comment. It does not go through the full process. So the problem I think the tax department has with guidelines is they get no deference in court. They give deference, obviously, to statutes and properly approved regulations. No other pronouncement by the state tax commissioner is provided deference. They might get judicial notice, like, okay, it exists, so what?
All right, can I just ask a quick question as you
Sure.
mentioned that? Yeah, obviously, when they're sophisticated clients, they can access the information, fairly readily. They might pay someone like you to get that information for them. What about underrepresented or lower income taxpayers? How easily can they access information that may be out there that may be not in form of regulations or even regulations? Is it a transparent kind of process?
It relatively is. I will commend the Virginia Department of Taxation. They have a good website. They publish all of their rulings. You can get the regulations, you can get the guidelines, you can get notices. Anything that the tax department puts out, they do post to their website. If you just Google Virginia Department of Taxation, there will be a tab there for rulings and policies, and you go to that, and it's got a Boolean search function. And frankly, it's really helpful. We have something called public documents. It's like a IRS private letter ruling. They're posted. Unless the identity, of course they're redacted, but if the subject matter would automatically self-identify the taxpayer, then those are not posted. They will also post circuit court, which is our court of general jurisdiction, which is where you would have your trial, decisions that are posted on their website as well. So if someone doesn't have access to Lexis or Westlaw or one of the paid tax services, they can get those for free. A little harder to find, but they are posted in the same way. And so I do think it's one of the better states, Les, as far as having access to there. One thing to keep in mind, you have to understand what an assessment is. I've got to kind of define it, and it varies between tax. So when we think of assessment, we think of the formal act of a government agency issuing a tax bill. Assessment can also be viewed in Virginia as the physical levy. So assessment can have two different terms depending on, you have to look at the context. But generally, I would say for the most part, it's fairly transparent. You don't go by the audit report, you go by the assessment notice, which is a one-page bill. And so those are the dates. If the tax department amends the bill, then that pushes out the assessment date. And that's important. As far as judicial challenges, the statutory presumptions are fairly similar to most states. Assessments are presumed correct. The taxpayer has the burden of proof. If you are able to rebut and establish, for example, fair market value, then it levels the playing field, and now it's just a preponderance of the evidence. So from the local tax, they're fairly good at that. At the state level, it really kind of depends. They're still kind of not sure how to try a case when they have to be in the lead. Just like in the federal system, if you have an IRS where you've rebutted the presumption and changed the burden, or they're assessing a civil fraud penalty where they have the burden of proof, it can be a little bit more cumbersome. Let me talk briefly, and then I'm watching my time, so if I do something, just throw things at the screen at me. When it comes to administrative appeals, so generally you have an audit. An audit is just what you would think it would be. It's like any other tax. When you get to the end and they issue an assessment, you have a couple of choices to make. And now let's first talk about the state administered taxes. The first is, do I want to administratively appeal this assessment? Well, the tax department just gave you a bill. Who do you appeal to? The state tax commissioner. Well, if they're auditing, are they also able to make a decision? Think of the IRS Office of Independent Appeals and the IRS, sort of similar, except you have much less due process rights in Virginia. In the old days, when you filed administrative appeal, if you wanted a hearing, you just asked for it. And we go shuffle down to the tax commissioner's office, and we'd be in a conference room with the state tax commissioner, deputy tax commissioner, the head of appeals and rulings, and then the actual senior analyst who proposed the disallowance or is working on your appeal. Those days are, for the most part, gone. The tax department very rarely will give you a in-person visitation. So what that means is, what are you filing? You're basically filing a letter. You're outlining the facts, you're laying out your positions of law. If you are going to have attachments and exhibits, they had better have been exhibits that were presented during the audit. You cannot present new evidence at the administrative appeal, or they're just going to ship it back to audit. So you got to remember the function. Audit is when you're developing the facts. Appeal is almost like an appellate record. However, in Virginia, we don't have a state tax tribunal. We just have the tax commissioner who gives a thumbs up or a thumbs down, but will issue a written decision. Then the question is, what if you don't like that decision? Well, you always have the right to go to court. Now in Virginia, you do not have to exhaust administrative remedies. So usually we'll look at something, and if the tax department's position is fairly clear, we'll usually just go right to court if we think we have a case. I advise clients on litigation. I give them a very honest interpretation. Litigation's expensive. I don't want them to spend their money on issues that they're just dead losers. And I do my best to try to get them to really just pick and choose the real issues that you have, and not, and frankly, you do better, I think, with a trier of fact. In Virginia, we have, our court is a court of general jurisdiction, so it's a circuit court judge. And at that point, you've got to realize that you've got to know the rules of evidence. You know how to do direct and cross. You need to be a trial lawyer. So my background was I used to be a federal prosecutor. I had an LLM in tax, and when I decided to leave the government, I wanted to do transactions. And they kept saying, well, but you've been in court. Here, can you go to U.S. District Court? Can you go to tax court? Can you go to state court? And I really was not overly excited about that. But after a year or two, the light bulb went off when I realized no one else did this. Virginia, unlike New York, where you have lots of tax litigators, you have very few real tax litigators in Virginia. I can count them on one hand. And so you really just have to be just like a commercial litigator as far as practice and procedure, evidence, and all those types of things. So that's kind of the process for state. I'm going to switch quickly to local. Les, I think I got about 5 minutes. Is that about right?
That's about right.
So I have another outline there called Assessment and Appeals of Local Taxes in Virginia. And I just mentioned that because depending on the tax, you have to, what do I say first? What is the statute of limitations? It's different for different taxes. Also, if I have an audit, I get an assessment, I don't like it, you have multiple options. You can file an application for correction with the assessing local government. That's called a 3980 application. You need to think carefully about that, because if you file one and you lose, you don't get the right to administratively appeal that. You're stuck with court. Generally, 3980 applications are designed for non-business taxes, for example, individual income tax. They're not eligible for an administrative appeal. So there, your remedy would be to go to court. On a good side, you don't have to pay to play. But there are some exceptions. So what I mean by that is you don't have to pay the tax. It's almost like deficiency litigation in tax court. In this case, you can file your action and collection is told until there's a final order. Having said that, there are some carve-outs. If the taxpayer has a history of filing frivolous claims, if they are look like they're leaving the jurisdiction or dissipating assets, much like a jeopardy assessment for federal tax, in those situations, the tax jurisdiction can go to court and lift the collection stay and seize assets. I have had that happen once or twice over 30 plus years. So it's a very rare, and I think both the state and local take it very, very seriously and don't just do it as a tactic. I think they really save it for those real cases. Now, again, with my business clients, they're not picking up and running away now. But if this was a criminal, if they were criminal proceedings, that's a different question. So just something to be aware of. You have to know who your assessing officer is, because when you're making an administrative application, you're going back to the assessing officer first. So the person, just like with the state, the person who gave you a bill, you're going in and ask them to correct it and you tell them why. Now we have an alternative, or I guess I would say complementary administrative appeal to 3980 called 3983.1. And that's for business taxes. It covers all business taxes. Our gross receipts tax, which is a nemesis of businesses, does not cover real estate. Real estate, you're always going to do Board of Equalization litigation. But if it's one of these business taxes, you can then, just like with the state, you can file an administrative appeal to the state who doesn't get any revenue. It's about as neutral as we can get. They're not real excited to have this jurisdiction because they get the grief of all the local governments if they make changes. But that's what we created, and I was part of the legislative process for that, to create a cost-effective and efficient remedy. We went from generally about 320, 330 local tax appeals a year to now we're under 15 a year. So I think the process has worked. It's cost-effective, doesn't require lawyers unless it's a really complex issue. And so I would say that at the end of the day, if you don't like the answer from the state tax commissioner, you can still go to court. Or you can just bypass the whole system and go to court, because again, no administrative exhaustion required. And again, it's the same court. It's the Court of General Jurisdiction. It's our circuit court. Every city or locality has one. These are judges generally don't have a lot of tax experience. I tried one last week on a unitary business tax, and the judge who's been sitting there for 25 years said he's never seen one before. Unfortunately for me, the Virginia Attorney General representative had also never tried one before, so it made the trial a little bit cumbersome, but because they just wanted to follow state law, and this was a pure federal constitutional case. So you just got to be ready for that. State local tax is wonderful. It's fun. It's kind of like practicing federal tax before 1986 when you can actually do tax planning. The states are a little bit farther behind. They're probably not nearly as sophisticated as the IRS when you have abusive transactions, which is a problem. Fortunately, in Virginia, it's not much of a problem. So I get to try real cases and substantive issues, and procedural issues, which is what makes me happy. And I think, Les, maybe I'll just answer questions if folks have.
Yeah, and as Nina mentioned earlier, please post questions in the chat room, and I could direct them. One question I had, Craig, is you mentioned statute of limitations a few times and your practice of not agreeing to extensions, and I know in the federal context, careful practitioners are often double and triple checking what the IRS believes is the correct statute of limitations, let's say on collection, and I wonder to what extent is that an issue in state and local practice, or are you concerned, or are there issues about whether there may be ambiguities or mistakes that are made in terms of what the state or local taxing authority thinks is the appropriate deadline?
Sure. So for merit statutes, it's pretty straightforward. It's all statutory. We have separate collection statute of limitations, and it's, again, fairly straightforward. Where it becomes difficult is if during the process the state or the local government has changed based on maybe filings, has changed it. What impact does that have on the collection statute? Generally in Virginia, if it's 5 years at the local level, that means they have to collect everything within 5 years. So I think it's relatively straightforward. I don't see a lot of collection statute issues. And I work with a lot of other law firms that are doing collections work that have questions from time to time, and it raises some really cool questions. But for the most part, we don't seem to have that as a problem area.
Excellent. Thanks so much, Craig. And
Sure.
Before we move on to Larry, I want to turn it back to Anna Gooch, who is going to talk briefly about the really important survey work that the Center for Taxpayer Rights and Anna has been spearheading concerning basically getting a statewide perspective on audit and appeals and state and rights with respect to across jurisdictions. So Anna, maybe you can update us on the progress of that.
Okay, there we go. So why are we here? Nina mentioned that we are conducting a survey with funding from the Rockefeller Foundation. And just for those of you who were here last during our first workshop, this will be a little bit of review for those of you who weren't able to make it. Welcome. So this workshop series sort of takes some of the results from that survey as we're getting results in, and we wanted to highlight certain things that we're seeing. So a lot of our panelists come from, best practices or maybe areas that need improvement that we've identified through this survey. So again, very high level, we ask about 200 questions on property tax, sales tax where applicable, sales tax with a very general definition, as we'll hear from Larry, and of course income tax where applicable. And then we divide the survey into categories. During our first workshop, we talked about return filing and what that involves. Today, of course, we're talking about audits, appeals, and litigation. And then as we move through the series, we'll talk about collection and taxpayer rights generally. I won't go into too much detail, but we wanted to do this survey because there are three main reasons. The first, of course, is, we wanted to have all this information in one place. We wanted to look at state tax procedure all in one place. But then we're also we know a lot of states, unlike the federal government, have balanced budget requirements, so income or revenue might be more protected by the state. And then there are also, as we'll discuss in the coming weeks, few states fund low-income taxpayer clinics to help with state tax issues. So there's not that opportunity for assistance and advocacy. And then there are also, as we're seeing, there are fewer opportunities for things like oversight groups and things that we typically see on the federal level. And so we just wanted to be able to look at each state, identify best practices, propose model legislation so that other states can come and learn from each other. But what I'll be doing, I did this during the first workshop, and what I'll be doing moving forward is sharing some very preliminary high-level results relevant to that workshop's topic. So today we're talking about audits, appeals, and litigation. So I just wanted to share some, just a few of the many results that we're getting in. So it seems like every state for which we have received a completed survey for has the authority to make document matching adjustments. So things like, matching information returns with what is reported on the actual return. Every state for which we have received results for assigns one employee to an audit, which is great. It gives the taxpayer one contact point throughout their audit. And this is an income tax to ask questions, provide documentation. Every state for which we have received a survey allows taxpayers to appeal before paying income tax. I will note that this does not usually apply in the property tax context. What we're seeing is usually the fact that a taxpayer has appealed has no bearing on the due date of property tax. So if they get the appeal in beforehand and it's resolved, then they don't have to pay it. But if they get it in after, they still have to pay the tax, and the audit or the appeal proceeds normally. But there's no tolling, there's no effect on the due date. Almost every state allows taxpayers to communicate with their auditor or equivalent electronically, which is great. They don't have to use snail mail or deliver things in person. But we're really not sure if states are taking appropriate measures to secure data. So, when tax, of course, in the tax context, personal information is being thrown around, social security numbers are everywhere. And it's just not clear if states are, when they use email, for example, are they encrypted? How are they protecting taxpayer data? Who has access to it? So that's something that I'd like to explore more. And then, as we'll hear, and as Craig mentioned, more than half the states have some type of tax tribunal, whether that's a separate tax court as part of their judicial branch or sort of a division of their executive branch that's still independent. But a lot of states don't. They have nothing that is separate from their Department of Revenue or whatever the equivalent is in that state. And so that really affects how taxpayers are approaching or are able to approach litigation if it comes down to it. So that's all I had to share. Really looking forward to the rest of this panel. And if you have any questions, feel free to put them in the chat. Thank you.
Thanks so much, Anna, for sharing that. That's important work, and look forward to the final results. And one of the challenges we see in this area is the different names that are applied to kind of similar taxes. And we're fortunate today to be joined by Larry Hess, who's going to talk about New Mexico's own version of a sales tax, which is referred to as a gross receipts tax. And Larry can share his insights from extensive experience representing taxpayers in this context. So welcome, Larry.
So it's still morning here, so I'll say good morning. First thing I want to do is thank Nina and Anna for inviting me to share this information about New Mexico gross receipts tax. I really appreciate the opportunity. As Les said, what we call gross receipts tax is what almost everybody else calls sales tax. And it's all the tax programs in New Mexico are administered by the Taxation and Revenue Department. There are, I think, about 17 different tax programs. There are two. One of the things that I would point out that I think is special and helpful to low-income people is there are two significant exemptions. One for purchase of groceries, and another for purchase of certain medical expenses under certain conditions. On the other hand, there are some aspects that are not friendly to sellers, especially to people who are not employees, but they earn income and they don't think there are businesses. And this is what blindsides a number of people that I have dealt with. They get audited, they have no idea that they were even exposed to that situation. The gross receipts tax also creates administrative problems for both buyers and sellers, because there are some complexities that are difficult for average people to deal with. The things that I think are unfair to taxpayers, or business taxpayers, are, as I mentioned, businesses that aren't even aware that the gross receipts tax exists. But also mentioned was that low-income workers often get saddled with taxes without any understanding that they're businesses. What sets this up is, in many cases, is that New Mexico taxes services, whereas most states tax just tangibles. So that means that gig workers, consultants, professionals like me have to file and pay gross receipts tax. It's not a very commonly understood aspect of New Mexico tax. And I think Les mentioned that there's a terminology issue. New Mexico calls the sales tax gross receipts taxes, where I think Craig mentioned in Virginia, there's a gross receipts tax that's totally unrelated to sales. People get audited for not filing or for underreporting. That's no surprise. The most common reasons with gross receipts tax is they may report taxable sales only and omit non-taxable sales, which the state ends up discovering a situation that looks like they've underreported. People are not familiar with that their services are taxed. Out-of-state businesses selling to customers in New Mexico are subject to gross receipts tax. Many times they don't know that. Sometimes I get calls from larger or more sophisticated taxpayers outside of New Mexico who are being proactive, but mostly they get audit notices and then they need to figure out what to do with them. New businesses in New Mexico don't always do their due diligence, so they don't really understand that they have, not only do they have gross receipts tax obligations, but that they don't know what to do about them. One aspect of this is that I found that tax preparers who are the first line of information that a taxpayer has a Schedule C, for example, don't tell their clients that gross receipts tax is important to them. Many times people will come to me, well, my tax preparer didn't even tell me. Even before that, I think that employers should, when they hire a casual worker, when they hire an independent contractor, consultant, they need to tell those people that they need to pay attention to gross receipts tax. And that I think is a failure. It's not even something that people, that my clients have told me, but I just think that's the first thing that should happen. So once, as far as making the system fairer to audit targets, I think the state should advise them of their responsibility to file in the future, and B, depending on the significance, or let's say the magnitude of the tax, forego the opportunity to audit past taxes. So I think the education aspect would be a whole lot more helpful than we have. There's a lot of good information available on the Tax and Revenue Department website about what people should do. There's often, it appears, well, why didn't you file? Why didn't you respond to a notice? And yet I think that providing more information will be a lot more helpful, especially to the smaller, more unsophisticated individuals who are, again, they get 1099s, they know they have to file Schedule C, that's all they know.
Larry, is there any opportunity for pro bono or kind of low bono representation for maybe the lower income or underrepresented kind of group?
Yes, definitely. In fact, I got involved with the low income taxpayer clinic here because of their contract with the IRS. They're not allowed to do representation of state tax matters. So they call on me from time to time, either for guidance or for referrals. And I also have taken pro bono clients on my own. So yes, and one of the Taxpayer Bill of Rights is the right to representation, and it doesn't restrict to fee paid representation.
Larry, I have a question. It seems, and we do have a comment and thing, but so this seems to me particularly problematic with gig workers. Like you drive for Uber, that's a service. Right. And so you are subject to the GRT. Is Uber or, are the platforms taking that out of your pay, or are you, is the person responsible for it? And then they don't, this goes back to your earlier point that they're actually paying for it because they haven't grossed up the charge for the GRT. So it's actually reducing their, their actual take home.
Yeah, you've just raised two things. One, there is no state withholding on independent contractors. There's nothing like the IRS Form 1045, 1042. There isn't backup withholding. There's none of that. So no business can withhold any tax for any state tax for independent contractors. Secondly, whether or not if someone is aware, a gig worker is aware of the gross receipts tax, whether they could gross up what they want to charge is really totally dependent on the contractor they work for. When people come to me, I certainly advise them to do that. Sometimes they're consultants and they say, well, I worked for this agency as an employee. I retired. I was making X dollars an hour. I still want to make the same X dollars an hour. What do I have to do? And I help them gross up not only the gross receipts tax, but federal self-employment tax as well. So most of the time, though, there's not the opportunity. The contracting company doesn't provide the opportunity. In fact, with U.S. government contracting, often, even though services provided to U.S. government contractors or to the U.S. government are subject to gross receipts tax, services, yes. Tangibles, no. Contracting, I've encountered situations where contracting officers will just say, you pay the tax, and it's in the contractual obligation that the independent contractor, the consultant, has to pay the tax. So that is definitely an issue, and it revolves around services only.
And I know we're getting a little bit tight on time, but we have a question from the chat, which is really relates to a broader question too. The question from Geraldine Cole, Centro Espada LITC, is about whether nurses are subject to the gross receipts tax. And I wonder more broadly, are there specific services that are exempted that are targeted maybe for various policy reasons why they might not be included in the tax?
That's also something I've encountered. I think you're talking about traveling nurses or nurses who are contracted for limited periods of time with hospitals. This actually goes with physicians as well. And yes, if in most cases that I've dealt with, the placement agency treats them as independent contractors. And so when they come to New Mexico, they have New Mexico source income that's subject to income tax and gross receipts tax. Now, one caveat to that is if their services are being resold under some circumstances, then there is a way to claim an exemption. That does not eliminate the need to file a report and claim the exemption. As I'll get to in a couple of minutes, the audit process, what triggers the audit process means that lots of people have to file even if they have no tax liability. So that leads me into the audit area. We have desk audits, and a form of desk audit is a managed audit. Interestingly, I testified as a witness for the Department of Justice in a tax fraud case against one of my clients, and the defendant hired an attorney from Florida because the attorney said he knew all about managed audits. And it turned out he had no clue. And so that term also, I think, if any other states use it, that's another terminology issue that can throw people. And then we have field audits. I'm not going to discuss field audits at all because, frankly, they happen to larger businesses, and that really is beyond the scope of my practice. In talking about audits, I think it's important to talk about the statute of limitations. It's a little different from the federal, the way the federal counts or starts the clock running. New Mexico starts the clock running on December 31st of the third year after the tax is due, whereas IRS clock starts when the return is filed, which means the statute of limitations in New Mexico can be shorter. If no return is filed, that extends to 7 years, and if there's fraud, it goes out to 10 years. The 7-year statute means that after 7 years, you don't have to file a return, period. The way desk audits happen almost invariably is that the state gets 1099 and Schedule C information from the IRS. They have a data sharing agreement. They download that data. They then compare it automatically to the gross receipts that have been reported to the state. And when they see a discrepancy that would suggest an underreporting, then the audit notice goes out automatically. Automated detection, automated audit notices. And the audit notice says, we propose that you owe us tax, penalty, and interest. Now, the audit notice then suggests or makes available contact information for the auditor, and also explains the opportunity for a managed audit. Managed audits are voluntary and they're self-audits. The auditor does very little other than sort of manage the process. The taxpayer has to request managed audit. Typically, it's a taxpayer either who hasn't filed or one who gets the initial proposed assessment. Taxpayer then submits to the auditor the information that should have been on the tax returns: total gross receipts, any exempt gross receipts. And with the exception of exempt gross receipts, no documentation is required, which means if I have in the case of a person who delivers mail in a rural area under contract with the USPS, had no idea that she was subject to GRT, got a notice, has now submitted basically just agreed with the auditor, yes, the 1099s from the government, that's what I earned, and that's what's on Schedule C. The auditor says great. They plug in the tax rate effective for the various tax periods, and that's the end of things. So managed audit is pretty simple in that regard, although when you get into documenting non-taxable sales, then things get very dicey because the types of proof that are required are varied. There's one proof, it's called a non-taxable transaction certificate. If they get that from the seller, the contracting company, and they can only get.
Let me just. I know the managed audit process is super interesting, and in the interest of time, we have about a minute left, so maybe you want to kind of wrap up, and then we can move it on to Christopher as well.
Sure. Okay. The benefit of a managed audit, and I think this is important, Les, that if they do the managed audit, there's no penalty or interest as long as the tax is paid within 180 days of the assessment. And even if the tax isn't paid, they may get a payment plan on which they'll be charged interest, but still no penalty. the penalty here is typically a flat 20%. One of the other aspects that a taxpayer has to consider when asking for a managed audit is that has to cover all the unfiled tax returns, not just the returns that are listed in the audit notice. So right now, they're auditing up through 2019. That means people with managed audits are going to have to include the tax for 2020, 21, 22. So that impacts the decision of whether they can follow through with the managed audit, although frankly, with the eligibility of the payment plan, it's kind of, to me, it's kind of a no-brainer. They have 72 months to pay off what they can't pay by the 180 days. As far as options, once they're in an audit, if they don't agree, there are a number of levels of supervision they can go to for review. That's also one of the items in the Taxpayer Bill of Rights. The statutes provide that after an assessment is made, they can file a formal protest, and they're not when you file a protest, you're not required to pay the tax. Whereas if you go to court, the tax has to be paid first. That also is part of the Taxpayer Bill of Rights. If they don't like, by the way, the protest is not handled in a court, although it is as I said, a statutory process, and it's conducted by attorneys, some of whom may have previously worked for the department, because at a time up to a few years ago, the department administered this process. Now it's independent. If they don't like the decision they get in the protest, then they can file within 30 days of the denial. They can file with the New Mexico Court of Appeals. Here's some of the Taxpayer Bill of Rights that I think are important, relevant to audit. They're in my outline, so I'm not going to read them. For collections, the statute of limitations is 10 years from the assessment date. We do not have offer in compromise. The reason for that is interesting, I think. The state constitution has what is called the anti-donation clause. Now that applies to a number of different kinds of circumstances. In the tax world, it means the state can't write off taxes, even though the 10-year statute has been reached. The liability is still on the books, but there's another statute that says the state cannot initiate an action to collect the tax except if there's still an active lien. They can after the 10 years, and liens have their own 10-year statute.
Larry, we're going to cover collection in another panel, so I think we need to move on to Chris, just in the interest of time.
Oh, sure. Well, this is what I have.
Yeah,
And
this is great.
I would invite people to reach out to me if they have questions or would like me to fill in some of the blanks. I would be happy to do that.
Yeah, and thanks so much. And the collection issues are fascinating as well, and I'm looking forward to that as we address that in greater detail. As our penalty issues, which come up, and I imagine in some frequency, maybe we'll have an opportunity to discuss penalties in the discussion phase today. We're fortunate to have Christopher here to share with us his perspective from the New York State Department of Taxation and Finance, and as the state's taxpayer rights advocate. So Chris, take it away.
Good afternoon, everyone. Thank you for having me, Les and Nina. I'm honored to be here. This is great to talk about state tax issues because I feel like they get overwhelmed by everyone talking about IRS issues, right? All tax practitioners really know IRS issues, and the state issues kind of get lumped to the side. So this is really great. So regarding New York State and the audit process, one of the first things that I want to point out is that back in the mid-90s, the state passed a law. We have a Taxpayer Bill of Rights, Article 41, and that provides a lot of information to taxpayers, rights for them to be able to affords them from everything through from the audit process all the way down through what we can and can't do during collection. And so one of the biggest things when it comes to the audit process is that we are obligated when we initiate an audit to send out a letter in non-technical terms, similar to what Larry had for New Mexico, non-technical terms about the audit process. And this is, we have two of these. There's a publication 130F, and we have a publication 130D. They're both like 3 pages long. They talk about the whole audit process from, your rights and responsibilities during it. So, taxpayers and practitioners have their responsibility that they need to communicate with the department as well during this process, which is good. And I think it gets lost in all the paperwork when you're provided, right? People are overwhelmed, they get an audit, they get upset, they have the appointment letter, they have the document request, they have other required documents in there, as this is one of them. So it could be a big stack of things, and this can get lost, but this is also available obviously on our website. So, all this information is out there, whether you have an audit or not. Talks about how you can record the auditor if you wish, talks about how you can have representation, talks about statute of limitations, talks about your, if you agree or disagree with the assessment. And, we can talk about that. It also talks about how you have a right to ask the auditor, why do you need this information? The auditor is obligated to give you a response as to why they need it. It's not like we can't just ask for the kitchen sink. We need to have a detailed response as to why we're asking for it. Most practitioners understand what that is. So, when I talk about these two, the question may be, well, why do you have two? Well, there's a Pub 130F and the 130D. One is for a field audit and one is for a desk audit. They're two very distinctly different types of audits. Probably 90% of our audits here in New York State are desk audits. I mean, I'm probably talking about we do maybe 200,000 a year of these audits combined between the two. So you figure maybe 20,000 account for field audit, right? And 180 or thereabout would be roughly for desk audit. So most of you would be dealing with a desk audit. And the difference being is that a desk audit is generally a 1 year, one line item issue, very simple. You can provide the information electronically. We have ways in New York State, avenues for you to be able to provide it through our online service account. And that's how you can provide us that information. That's a relatively quick process. It does take the auditor sometimes. It's not an auditor, it's a group that reviews the information and they provide you a response. In that response, you can agree, disagree, they may be asking for more information, but like I said, that's usually a couple months. The other type of audit is a field audit, and as that's completely different, is that you're assigned an actual auditor. We have 11 district offices here in New York State. They travel all over the country to go do field audits. So, they can come to your state, they can talk to you about whatever tax type we are. Usually it's personal income tax, sales tax is a big one, obviously, corp tax, withholding tax. Those are the 4 main ones, obviously, that we do, but we will travel to your office location, do audits. So there again, when you're talking field audit, you're also talking probably larger taxpayers, larger dollar amount here. So for the common person, that's not what we're dealing with on the field. We're not dealing with field audits. But there again, it talks about what's required by the auditor, talks about the opening conference. The auditor always has an opening conference with a field audit, and it goes through that process. In the audit process, another thing that came out in the statute with the Bill of Rights is that if an auditor identifies an overpayment, they have an obligation to tell the taxpayer of the overpayment. Doesn't mean that I need to go through and I need to account for all the times that you pay tax on an item you shouldn't have and account for it. But at least if I identify it, I can share it with you. You can go and compile the information and you can file a refund and we can handle it on the audit. Same thing, if I see something within the audit period, right, and a payment that you missed, it's my obligation to present it to you so that we address it and bring it forward. And you get credit for that. So, it can be tough at times when you're dealing with audit. They ask for lots of information. Bigger the audit, the more the information can get quite extensive, but at the same time, we, give you time. And then talking about giving time, as Craig mentioned with the statute of limitations, he's very hesitant to. I find that it's actually quite opposite in New York State, where most tax practitioners are overwhelmingly happy to almost sign a statute of limitations to give them more time. So, it's a ebb and flow trying to figure it out, which is the best. If we issue an assessment, depending on how the assessment is issued, it can make it difficult for a taxpayer to come in and provide the information after the fact. So like most states, New York State is 3-year statute of limitations with most of the tax types. One of the important things to note is that when we're talking about the document matching adjustments, we call it like a tape match here at New York State. When we get information from the IRS, we do not have a statute of limitation when it comes to IRS tape matching issues. So you can have a taxpayer who has an IRS audit going on. There could be an adjustment that could happen 5 years after the statute of limitations is due, but there is still an obligation within New York State for you to notify us and for you to amend your return. So even though it's after your 3 years of filing with New York State, you still have an obligation to amend your return and notify us. And we're probably going to find out and we're probably going to bill you years later. And one of the biggest problems that I have with that is we have to mail a bill to your last known address. So when taxpayers leave New York State, our obligation is to send it to your last known address. excuse me. And it's your obligation as a practitioner or taxpayer to notify the state of an address change. And if you fail to do so, in the tax courts, we have done our job. And this is the problem that I come across many times, is that people move, maybe they move a couple times, they don't change their address with New York State. They think, oh, that was 2 years ago, maybe 3 years ago, I don't change it. Unfortunately, we mail it to your last known address. We've done our due diligence. And many times people find out about a tax bill on the state side because they have a warrant issued against them because they never addressed the tax bill. And I'm not going to go down the collection side of things, but if you do have a audit going on, whether it be a desk audit or field audit, and if you do not like the answer, you don't like where it's going, you don't like the outcome, you would receive a notice of deficiency or notice of determination, very common terminology amongst many states. And in New York State, it has to be certified. So we mail it certified to the taxpayer. If you are the POA on file, we are obligated to mail it to you as well. Probably about 25% of our court cases are just cases about people arguing the mailing procedures in New York State. That really is, they want to claim that we didn't mail it properly so that they can get their rights back. Because if they can prove that we didn't mail it properly, then the statute of limitations for them to file with the tax courts is extended. And so if we've mailed you the right document, you have 3 options. If it's small enough, you can go to small claims court. Pretty rare. We don't see it very often, but I'm just going to mention that. The second option is the Bureau of Conciliation and Mediation Services. This is the biggest one that we have. Most people do go here, and I'll talk about that in just a minute. And the third one is Division of Tax Appeals, and that's tax court here in New York State. So when I talk about Bureau of Conciliation and Mediation Services, it's a long name. We call it BCMS, right? Every state loves their acronyms. So we have BCMS, and it really is I think, a friendly way for a taxpayer to come forward to the department and to kind of argue their case. Now, what is it? It's a conference. We have a conferee. This conferee is a tax department employee, so people don't like that. But I will say that they're trying to resolve the case. That is their primary purpose here. They want to prevent cases from going to litigation. Litigation is expensive for everyone. They know not everyone can go to litigation. So it definitely is a way for them to try to resolve it. And it's really a conference. You meet in a room, you have a conferee, you have someone from the department to argue their position, and you can come in as a taxpayer or tax practitioner, and you just lay out your information that you have. It may take, usually they sit down once and the rest of it is done through correspondence, but it may take a little while, but it is a pretty seamless process that doesn't take a lot of time. Because of COVID-19, it used to always be required to be in person. Thankfully, we've changed that, and now we allow people to do this over the phone. So people don't need to get in the car, drive an hour or two to an office, or get in the subway, like in New York City, take the subway to get to whatever office for these meetings. We allow them to do it over the phone. They could be short. They could be a half hour long. Doesn't need to be very long because the issues may not be very big. But the conferee reviews the information, and at the end of the day, they make their determination. When they make their determination, they could side with the taxpayer, and the auditor may not like it, but they kind of are they kind of have to deal with what the conferee deals issues. So, as a former auditor, I can sit there and say, I didn't always agree with the conferee, but they did do their job. And I think that's really at the end of the day, they're trying to prevent the messy cases from going to litigation. Now, if you have a case and you're really talking about the taxability of an item or whether a person is resident or non-resident in New York State, many times, they kind of get punted to the Division of Tax Appeals. And so if the taxpayer, again, doesn't agree with what the conferee issues, there again, you can continue your appeal rights and you can go to the Division of Tax Appeals. And in New York State, there's two levels. Division of Tax Appeals, and we have a tribunal. So the first one is a court hearing. We have an administrative law judge who presides over the hearing. You generally would need to have a lawyer there and go through that process. We're talking many years, though, from the time that the bill was issued to being heard from these, as they take a long time, unfortunately, these days. That's our tax administration process. One of the things that really is beneficial to taxpayers, I find, in New York State, is we have an online service account. And with the online service account, you can get notified as a tax practitioner of all assessments that go out to your clients. And you may not be the power of attorney on file, which is fine, but at least you can be notified that they received a bill, and then you can call up taxpayer bill and say, taxpayer bill, why do you have a bill for $2,000? You say, oh, I don't know. I didn't open up the mail. Well, that's a problem. And at least you can address it as a practitioner and make sure that they appeal their decisions, because that's one of the biggest problems. Taxpayers don't like opening mail from the tax department. And how do you get them to do that? And as a tax practitioner, by being able to see into their account and file makes it easier. Our new taxes are all going online. We have opioid tax that has to be filed online, cannabis tax that's coming out. We have recreational cannabis now, but it's not completely out, and it's all online to prevent from mailing things. But unfortunately, some of these older taxes, the tax law has been written decades ago, and we're still dealing with, you have to mail it to them. And while it may not be the easiest way, that's the way that the law says. And that's unfortunately what we have to deal with.
In the interest of time, we have under 5 minutes. I want to make sure you can help us focus on the importance of the office in which you sit, and how that kind of relates to the overarching kind of process you've discussed, and maybe, you know, compare and talk about the relation to other states as you may perceive.
So the advocate's office at New York State is very different from the IRS, but I find that many other states are actually similar to New York State, where the advocate's office is an internal unit within the department. So I do work closely with all the other divisions in the department. I know what's going on. I know what's coming out. But that also gives me a say in what happens with our forms, our processes. We can make sure that we're billing people correctly, we're reviewing assessments correctly. And if anybody has any questions, you know, they can come to the Taxpayer Rights Advocate, as I will direct you to the right avenue to go. People they don't know, they've tried all their avenues, and they say, I don't know where to go. It's easy, come to my office, I can direct you to the right unit. Doesn't mean that you're gonna get a happy answer, but at least I can direct you to the right group. And I will always tell everyone what their appeal rights are. Most assessments do have a prepayment right in New York State, unless it's like a math or clerical error, where then you don't get a prepayment right. But there again, we do have a post-payment right of, you have 2 years from the date of payment to file for a refund, to then be, and that's kind of where the advocate's office works in the state here at New York, is we're just trying to get people to understand how the department works, and the department knows that I'm here always kind of looking over their shoulder. I report directly to the commissioner. So, you know, if I don't see something I don't like, I can bring it to her, and Commissioner Hiller will make a decision what she likes or doesn't like.
And how much of a role does the advocate's office play with broader systemic issues? I know that's an important part of the statutory rights in the federal system. Is that part of the you know, your office's responsibilities and
Yeah, and I want to,
We
Wayne,
do.
you talked about the last known address, and that was a huge issue for me, you know, how the IRS archaically defined what the last known address was in the 21st century, how much time it gave itself to update its addresses on its systems, you know, in the 21st century. So I'm wondering, you know, you expressed some concern about that. What work have you done on that? That's a big issue for sure.
It is a big issue. We try to utilize whatever address we have. The problem is that by the tax law stating that I need to mail it to your last known address, you know, the department kind of throws their hands up. They all kind of throw their hands up, unless there's a big legislative change. But the problem is that, you know, some people kind of throw it back at, well, we do have an online service account. If you sign up for the online service account, you get notified that you received a bill. So even if you've moved 5 times, you would still get an email to your email address, you know, 5 years later saying, hey, you've received a notice from the tax department. You can log on to your online service account and you can see it. So while that does make things better, it doesn't make it perfect. And there again, I think that's where the department, though, identifies that mailing out notices is costly and it doesn't get the right information to people. They're moving things to be online. All of our new legislation is for online filing, online assessments. So the whole process is done online as opposed to being done through the mail. But to sit there and try to get, you know, the personal income tax filings removed as from being, you know, assessments being mailed is a very difficult thing to do. So it's hard, but we know that there's something needs to change, but that's where I'm pushing the idea, like, don't forget that you need to update your address, right? Filing your return once a year. While that does update your address, that may not be sufficient. And so we do have avenues like your online service account to update your address whenever you do move.
Excellent. We have about a minute, Chris, if you want to wrap up, and then we'll move on to the judge.
So I just wanted to point out that, you know, we can continue on with your protest appeals process, even through the tax courts. You can file Article 76, which allows you to go to the state Supreme Court and Court of Appeals in that avenue. Again, that's rare, but I just want to point that out there, that Bureau of Conciliation Mediation Services is really one of the best avenues that we have to solve low income or moderate income tax issues without having to go through a real full tax court system to get a resolution.
Thank you so much. And it's a natural move for me going from New York to New Jersey. Was born in Brooklyn, moved to New Jersey as a young child. So we're thrilled. Judge Sundar is going to share some insights on New Jersey's practice with setting up a separate part of the judicial branch, a dedicated tax court. So welcome, Judge.
Thank you. Hello, everyone. I'm really glad to be here. Thank you all. And yes, New York, our cousins said a lot of things that are very, very common to New Jersey, including the distressing part about the mailing last known address. I know when I was representing Division of Taxation, taxation would take additional measures. So for example, if there was a pizza parlor getting audited, the notice of assessment audit, and there's a CPA representing them, taxation would automatically just send an additional copy to the CPA. Just so, here we know that you were represented, the representative also gets it. But yeah, a lot of things that New York is in common is in Jersey, except the tax court. We are part of the judiciary. We were established in 1979. We were basically created to replace an administrative agency, which is the Division of Tax Appeals. And that was a body that was within Division of Taxation, sort of reviewing each other's decision, didn't look really good and fair. So the court was established in 1979. If you go to the next slide, I think it is that we are have to have 12 judges, not more than 12 judges, not at least 6 judges. Currently, we have 11, including one who's retired and is back on recall. By statute, people like me, you have to have practiced for 10 years before you can even apply to become a judge. And one of the qualifications, or we should have some expertise in the tax area. Hopefully, what I guess the issue in Virginia, Craig said, will not happen. So when we get tax issues, we really know what we're looking at. But that's by statute, we're required to do that. The first person, in fact, to push for the tax court was Judge Lasser, and he was instrumental in creating the court, the organization, the court rules. The next slide, please. Administration of the cases is not done by the courts. It's called the Tax Court Management Office. They do the case docketing. When the case comes in, they give a docket number. We have, like New York, everything is now electronic. Attorneys by court rule have to electronically file everything. They have no option to send in a paper filing. If they do, they get a deficiency notice saying, hey, register and file electronically. Self-represented, no pressure. If you want to, you could do it. The Tax Court Management Office helps them to do it. You basically give your credit card so that it'll be charged, and then you basically upload everything. But if we get a paper filing from a self-represented, no issues. They also do the follow-up case management, trial notices, judgments. If there are records requests, I want to see what was the pleading. In this case, Tax Court Management Office does that. They do everything. When we get the complaint, you check off whether you need any kind of disability ADA accommodation, you have language issues, the court will provide everything that is needed. Interpreters are provided at the court's expense. ADA accommodation, we do everything. But there are sometimes we just, if you can, we're not going to just say because I don't feel like coming into court, court bothers me and I can't stand the look of Judge Sundar, but I want to be at home. Sorry, that's not an accommodation. We're not going to do that. Tax Court Management Office does a lot of data collection and dissemination to the tax bar, to the tax world, and for our internal purposes. The next slide is our jurisdiction. Because we're created by the statute, our jurisdiction is limited by the statute, and I've just put it in there. We review any state agency action, county board of taxation, any official, but relating to tax. There are what is called superior courts, which courts, divorce, civil, criminal. If that court requires resolution of an issue that has tax court expertise, they can ask us to deal with it. So we deal with it, and we do it either they transfer it to us or we transfer ourselves to that court. have to decide, again, this is by statute, all issues of fact and of law de novo. So it means, like New York was saying, New Jersey is also set up, Division of Taxation, for example, has an internal administrative review. And they make a decision and they say, for example, I find this audit 100% okay, or I find this audit 80% okay, I'm going to give you a relief for the 20%. When it comes to the court, I can look at everything from scratch. So that's, even though it's technically an appeal from the final determination, we look at everything anew. We can grant legal and equitable remedies in all cases. So we do, even though we're statutorily created, we have the power to exercise our equity and give relief. The next one is just a picture of jury panel. I am the judge and the jury. So there's no jury system. We're the fact finders, we're the law. The objectives are essentially, and this was very well stated, I think, effective, expeditious, inexpensive, convenient, equitable judicial review of state and local tax matters, consistent, uniform body of tax law. And that's really important. We do our opinions. We say to the tax world and the tax bar, including the state agencies, this is how we think this particular tax survives, doesn't survive. We have, so basically, like I said, an informed state and local tax bar. So the bar knows, okay, I have this issue. This is where the tax court would likely, rule this way, or maybe not this way. And we've, have a very congenial relationship with the tax bar. And they also bring to us issues. They say, Judge, and they can write to us saying, this is a good case. We want it published. And we will look at it and say, okay, maybe yes, maybe not. So there's that collegiality, which kind of leads to my next page. Opinions are published and reported in the tax court reporter, which is the next slide. And if we're just issuing a letter of opinion, dear Miss Olson and Mr. and Professor Buck, you appeared before me and this is what you argued and this is my decision. That's called a letter of opinion because it's kind of formatted like a letter. We put this on our internet. We keep it on for the internet for, I think there's a year limit, and then it goes on to Rutgers Law is our law school, obviously, and it goes on their website for free. You can access it for free, and they have a phenomenal database, including laws, statutes promulgated back in 1800s. So it's a really good one. All of our judgments, our final judgments, go to the appellate review, which is the appellate division in the superior court. So it's just like we're a trial court. You don't like my decision, go to the appellate division. And then, they decide, obviously at the appellate level, there's just attorneys arguing or self-represented and the attorney arguing. I put in kind of the next slide, the proceedings in the tax court. This is what we're doing it currently. They're all recorded via what is called CourtSmart. If they're held remotely, which is 90% of the times for state tax cases, they're live streamed. So you can go, it's like YouTube. I'm a dinosaur in those terms, but I'm thinking YouTube. You can click on it. We have on our NJ Court's website a drop-down menu called Public. You click on Public, it goes to live stream. You click on live stream and you can see the name of the case. You click on the case, hit play, and you can see the whole recording. We have to live stream because if you were in court, any member of the public can walk in and watch. So that's kind of like the equivalent of electronic. Most state tax cases are without a trial and summary judgment motions. Essentially, is this transaction an exempt transaction? Was this properly reported? Was the deduction properly taken? For the most part, the facts are not disputed. So the taxpayer and Division of Taxation agree. And really what is before me and the other judges are questions of law. So we really don't have trials with witnesses, although that's, also happens, but the percentage is very low. The next one, I think it's pretty obvious, is that all state taxes are administered, assessed, collected by New Jersey Division of Taxation. So in a complaint, the plaintiff, 99.9%, I would say 99.99999% is the taxpayer, and the defendant is always the Division of Taxation. Division of Taxation is represented in court by the Attorney General's office. You have what is called the Deputy Attorney General. I was one of them, and I represented them in court on all litigation. And just like New York said, after taxation makes its assessment, you have 90 days to go to conference and appeals within the Division of Taxation. And once conference and appeals issues what they call the final determination, same thing like New York, you then go to appeal at the tax court. I have just put after the complaint is filed, internally what we do, we make sure that if the plaintiff is a Inc., LLC entity, you need an attorney by court rules. So usually what happens is we send them a notice saying, hello, this is the court rule, you're an entity, you need an attorney, and we give them plenty of time. We're not pressuring them. So I do sometimes in order to show cause, get them in, and sometimes it's, I don't want to pay an attorney. And I say, I know I feel sorry for you, but this is our court rules. In the meantime, we try to do something creative, try to talk to Division of Taxation, see if you can settle it. And if you can settle it, maybe you can withdraw the complaint and you don't need an attorney. So we try to come up to help some of the little mom and pop stores who are created as an LLC or an Inc. because their CPA told them this is a good way to go. The other thing we get involved in is the filing fee. It's $250 for the first state tax. So for example, if taxation does a cash audit and says you did not pay sales tax for X years, because of the sales tax, you now also have a corporate income tax if you were created as a corporation. And because of that, I'm also imputing some salary income to you, because all of those profits that you supposedly made had to go somewhere. It presumably went into your pocket. So you have $250 for the first state tax, then $50 for the next two. We do get people asking us saying, I can't pay this fee, it's too heavy. I want a waiver. And then I, as the presiding judge, look at it. They have to give me some documents to show why they're sort of at poverty level. And then once I issue an order, I say waived filing fee, and then they could just proceed on the complaint. After the complaint is filed and the DAJ files an answer, then we do kind of case manage it, status conferences, discovery, settlement. And if there's no settlement, we try the case or we do for summary judgment. The next slide kind of shows the kind of taxes that the tax court handles. I haven't done any local property. We do a lot of local property. State taxes are corporate, personal, debt. I mean, the corporate is like a corporation business tax, sales and use tax. There's so many taxes. I put in the bottom the website for New Jersey Division of Taxation. They have a list of taxes that I did not know existed. So I think everybody will be enlightened to know that New Jersey has tons of taxes. The next one is what everybody so far, next slide, has emphasized is timeliness of the complaint. If the complaint is not timely filed, my hands are really tied because it is a statute of limitations, strictly construed. And the only time, like in New York, is I never got it. And then I would have a hearing saying, why didn't you get it? And when I was a DAG, there was a lot of litigation. If you look at New Jersey Division of Taxation's final determination, it's phenomenal. I mean, they give you everything. And like New York, and I think New Mexico too, there's a state tax uniform procedure law which says explain to them, say everything in non-legalese, make very clear this is your statute of limitations, and provide the address and the venue for the complaint. So taxation's final determination has all of this information. So it's very difficult for the taxpayer to say, I didn't understand where to go, when to go. So usually the issues are, well, I never got it. And then sometimes we have a hearing, and depending on what comes out, it comes out. On this one too, we do help I would say the low income and or self-represented, saying, look, if you need, this is the time that you might need some legal help. We refer them to legal services in New Jersey. We've created this pro bono program, which I'm really proud of. We just did it this year. We put it in our court rules. You can go to legal services. Legal services can then farm it out to an attorney and say, hey, take care of this case. And then the attorney comes in and does pro bono. They can also give it to a law school student on simple cases. We have simple as in like property tax rebate. I'm a senior citizen. I have X amount of income. By law, I'm entitled to get, let's say, $250 as a rebate. And at that point, I would say 100% of the cases we get on that from Division of Taxation's denial are self-represented. They're, elderly people, sometimes with disability, and we created this system for pro bono and legal services just to help these people. To help the elderly. We do a lot of accommodation. We don't make them come to court personally. If they say, I'm, old and I really don't want to come to Trenton, we try to do everything. And in New Jersey, we even give them tablets so that they can do it remotely. It's the judiciary's tablet. We sit there, we explain to them how it is. They pick it up at a courthouse or a location convenient to them, take it home, do the hearing, and then return it to us. So we try to help them out a lot because it's just, they are a vulnerable part of our society, and we're not going to make them, you have to come to Trenton and drive, 35 miles, just so I can tell you, no, you're not going to get your rebate. So we try to help a lot with the legal services. I just kind of put in the kind of issues on the next 3 slides on the typical issues that we have. Corporate income tax, we have Nexus, where a lot of the big corporations say, Professor, it's the next slide. Yeah. Don't touch me. I'm getting a lot of income from New Jersey, but I have no nexus to you. Constitutional issues. Add back or New Jersey getting frustrated with, I'm not able to touch these outside companies. So they say, I don't get you. I'll get your guy who's working here and deny him deduction. Net operating losses, we have exemptions. And then cash audits. Cash audits are the markup where Division of Taxation goes to a business and says, show me all your books and records. And if the guy's humming and hawing, or the girl's humming and hawing, and they're giving like not enough, taxation can do, and I think this is also in the federal income tax, they mark it up. And they say, this is what you would have gotten and reported had you kept your books and records on a proper basis. And then penalties, interest, and then it comes to me. So we do that. That's part of a corporate income tax. And then the next, we have typical state tax issues. As New York was saying, or I think, was it New York or Virginia? I'm not sure. I think New York. Federal income tax audit changes your New Jersey income. You have the obligation under statute to report it. If you don't, there can be an audit on that. Disallowance of deductions. We have very limited deductions. New Jersey is a gross income tax. So it has its own little statute of what you can deduct and what you cannot deduct, not like the feds. Then the property tax rebates is what I just talked about with the senior citizens and the disabled. We do not have innocent spouse relief like New Mexico. And so we've had litigation on that. And I am maybe I should brag. I kind of found a way around it to get the case settled. So they got the case settled. Credit for taxes paid to other states. If you're working New Jersey, New York, the whole idea is no double taxation on the same income. And then we have the inheritance tax, what compromises taxable estate and usual. The tax on inheritance, unlike the estate, the tax incidence is on the person getting the money. So if I die and I give Professor Bach $100,000 and he's not related to me, he has to pay tax on 50% of it. But he can say, hey, you know what? I had to pay the lawyer this, I had to fight on this and all of these deductions. So if the estate is reduced, then his share gets reduced. So he can fight about that. And then contemplation of death. We've had some very interesting cases. And I think this law is pretty much in every state. I'm really, really sick. And I call my whoever I love coming in and saying, you know what, I don't think I can make it. So here, I'm going to write you all of my property for you. Get $1 million. And this was a reported case I did, so I can talk about it. The individual was older gentleman and gave shares of a company, stock in a company worth about, I can't remember, it was in millions of dollars. And then he passed away. So because it was within 3 years of his death, this transfer was within 3 years of his death, the presumption is that it was a gift made in contemplation of death, and therefore it is taxable. And it's really hard because the person is deceased and he's not going to come on stage and say, there was no way I did this. I knew I'm going to live. I had no expectation of death. So it's a little difficult, makes for a lot of interesting case law, but very, very, very fact intensive. as you can see. So this would be one where we would have a trial, we would have witnesses. I had one where the doctor came and said the person was in excellent health, the fiance who received the stock and said, and all the pictures. And so you then make your decision based on that. And I just kind of summarize the whole thing. Division of taxation is always a defendant in a state tax case. DAG always represents the division of taxation. On the right-hand side, I said first comes the auditor who audits, then comes the conferee who is conferencing the case at the administrative level. The liaison is also from taxation, but it's after the case is in court. And I do say must read the audit report, the conference report, and the final determination. The audit report helps the court enormously. The auditors, at least for me, from Division of Taxation, do a phenomenal job in explaining what happens in the audit. They write it out, and it's part of the evidence that they put it together for me. That is the basis of the audit. And because that's what carries forward to conference and appeals, which can be like very summary, like I like what he said, it stays. Doesn't give too much of, help to me, but the audit report is very detailed, explains what was looked at, what was the problem, and it really helps with the court in doing this. And the final determination.
And there's so much that New Jersey has as a model. It seems like there's a lot of really good things going on. And I know I want to make sure we have time for Professor Sams, but we could probably have a whole panel on different state judicial, tribunal approaches and independent judiciary. You mentioned something about New Jersey having your court having equitable jurisdiction. Can you just briefly expand on that before we turn over to Professor Sams?
Yeah, equitable. I mean, again, I think the statute limits taxation in terms of, for example, interest on the taxes. You impose interest on the taxes automatically. By statute, taxation's hands are tied. They don't have the ability to exercise, although they might. I don't know. Internally, they might do it. I have no idea. But sometimes the individual comes to court and says, Judge, I filed my protest to the Division of Taxation 1981. By the time they told me that, yes, I'm affirming the audit, it was 1985. So for 5 years, the interest has been, accumulating since we also don't require taxes be paid in order to litigate. It's not my fault. Some judges say too bad. I look at stuff and say, is it really equitable or inequitable, and try to do it. Taxation, they have no choice because the statute said you tax shall impose interest. At the same time, they say you taxation may abate penalties. So their hands are tied, and that's where I would look into equity.
It's fascinating. Thank you so much. Really terrific stuff. And Mike's gonna talk about some of the challenges of differing parties involved when there are disputes that involve state tax issues, and in particular, Mike's going to share some insights with respect to Pennsylvania. So, Mike.
Okay, sorry about that. No, I was just saying thank you very much, Les, and thank you, Judge Sundar, for that wonderful presentation. And I think that the New Jersey Independent Tax Court is a model that should be repeated around the country. I think it's great. I've had the pleasure of appearing before Judge Bianco and many years before that, Judge Small. And I think it's a very fair court and a very well-run court. So with that, I'm going to turn to some issues in Pennsylvania that may not be so well-run, but it's not necessarily because Pennsylvania doesn't have a tax court. It has a Commonwealth court, unlike New Jersey. And in the Commonwealth court is where all tax claims against the Commonwealth are brought. And the issue that I'm going to talk to you about is where a taxpayer brought a suit in the Commonwealth court. And similar to New Jersey, where the Attorney General represents the Division of Taxation in New Jersey, in Pennsylvania, the Attorney General represents, well, that's the question in this case. Who do they represent? Who represents the Commonwealth? Is it the Commonwealth or the Department of Revenue? And if the Office of Attorney General and the Department of Revenue disagree on the interpretation of a statute, whose opinion and whose arguments should be brought forth in the Commonwealth Court. So this is a real problem because in the state and local tax world, we have so much ambiguity, so much uncertainty. It has so many, not just financial statement implications, but reputational implications. All sorts of collateral damage can result from the uncertainty that we see in the state and local area. So what happened in this case I'm going to talk about? The case is Synthes, and what happened originally was the Office of Attorney General was served, and because that's what the statute requires. It says the named defendant is the Commonwealth, and you have to serve the Office of Attorney General, and the Office of Attorney General will represent the Commonwealth, shall represent the Commonwealth. Well, what happens is the Attorney General and the Department of Revenue don't agree on the interpretation of the statute. And so the Department of Revenue intervenes. So now you got to sit back and scratch your head and say, wait a minute, the Commonwealth is already represented by the Attorney General, and now we have the Department of Revenue coming in to assert a mutually exclusive position. And in the its application to intervene, the Commonwealth says that the Department of Revenue says the Commonwealth has taken a position before this court that would alter drastically the department's longstanding interpretation of a statute. So the substantive issue is a sourcing statute, the interpretation of a sourcing statute for corporate income tax purposes. We're not going to get into that. I'm going to talk about the procedural issue, is what happens when the Office of Attorney General and the Department of Revenue disagree on that interpretation, and whose interpretation controls. So like I said, the Attorney General was served. They represent the Commonwealth. And here in its, and the Commonwealth Court repeated this in its decision, in its application to intervene, the Department of Revenue says that the Commonwealth has taken a position before this court that would drastically alter the department's longstanding interpretation. So adding to all the ambiguity and uncertainty that we have in the state and local world to begin with, this exacerbates it. I'm not going to go into any detail here on what happened, but the originally Synthes filed a return applying the Attorney General's interpretation of the statute. And then they said, wait a minute, if we apply what we understand the department's interpretation to be, we're entitled to a refund. So they filed for a refund. The appellate boards denied it. And then we get up to Commonwealth Court. And the issue is, who represents the Commonwealth? Whose interpretation of that statute controls? So Commonwealth Court hears this. And I want to point out quickly that this was a refund. And the case is still going on, as you'll see. We're awaiting a decision. I checked the docket of the Supreme Court at least twice a day now. It was argued back on March 5th in the Supreme Court after this Commonwealth Court decision. And we're still awaiting a decision on the 2011 tax year. So I think Christian was saying something about the New York, how long it takes New York. Judge Sundar was telling us about how long things take in New Jersey. In every state tax court, it takes, I would think, a minimum of 6 to 8 years, if not longer, for a case to wind its way up to the highest court of that particular state. So Commonwealth Court said that the Department of Revenue's interpretation controlled, and they went through the whole statutory construction analysis. And then they dropped a footnote 12, that they said, with dismay, we note with dismay that the Attorney General asserted a legal position directly adverse to that of its client, and they did that instead of avoiding an unseemly conflict between the Commonwealth and its own agency. And then they went on to hold that the Department of Revenue was entitled to intervene. So in the beginning, when Professor Book was so kindly introducing me, he said that I was Talmadge's chief tax counsel back in the mid-90s. And that's the case. But in that era, what would have happened is that the governor and the Attorney General, so the Department of Revenue is it's in the executive branch, it reports up to the governor. So the governor And the Attorney General would never have let something like this happen. They would never allow this kind of dirty laundry to be aired in public. They would have gotten together and said, okay, I disagree with your opinion, or their representatives would have gotten together and said, look, I disagree with your opinion and the interpretation of the statute, but we've got to figure out a way to litigate this issue and have a court tell us whose interpretation is correct. But we're not going to do it with both of us going before the court, because that's going to look bad for the Attorney General, who is a separate elected official in Pennsylvania, and the governor. It's going to look bad for both of their administrations. How this got here at this point, there are all kinds of backstories, which I can't share on something that's been being recorded and broadcast publicly. There are quite a few stories as to how this got here. And frankly, my personal opinion is that it should not have gotten here. In the end, so they just drop in a footnote. The majority drops in a footnote. That this is conflict, and I think they were correct. This conflict should have been avoided. They allowed the Department of Revenue to intervene. They upheld the Department of Revenue's interpretation. Judge Sundar, unlike most of the decisions that I read from the New Jersey tax court, I disagree with with that one. And then in the concurring opinion, Judge Brobson, who has subsequently been elected to the Supreme Court, and that's another important note here, is that judges in Pennsylvania, both at the Commonwealth Court and for the Supreme Court, are elected. So Judge Brobson was elected to the Commonwealth Court a year or so ago. He was elected to the Supreme Court, but in his concurring decision at the Commonwealth Court, he wrote separately to emphasize his agreement with the majority's conclusion that the Office of Attorney General overstepped its authority under the Commonwealth Attorneys Act. The Commonwealth Attorneys Act is the act that sets forth the jurisdiction, if you will, of the Attorney General and the Department of Revenue. Again, I respectfully disagree with Judge Brobson's, now Justice Brobson's conclusion here. So it was argued March 10th, 2022. There was a post-argument submission saying, hey, there's this Texas court that has come out subsequent to argument that shed some light on our interpretation of the statute. And now we're faced with a situation where typically you would have 7 elected judges on the Pennsylvania Supreme Court hearing this case. Well, because Judge Brobson wrote the concurring opinion at the Commonwealth Court and was at the Supreme Court when this was argued, he's not a vote. So that leaves 6. Unfortunately, a month or so ago, the Chief Justice of the Pennsylvania Supreme Court passed away suddenly. So that leaves 5 justices who heard this. And now we're in this limbo. And I'm wondering, frankly, whether we're going to have this case rebriefed and re-argued if there was say a 3-3 decision before the unfortunate passing of Chief Justice Behr. Bottom line here is a lot of confusion, a lot of ambiguity that frankly could have been avoided.
And Mike, I know we only have a few minutes and people will be signing off, but can you maybe share some insights on how unusual it is to have the state's Attorney General representing the state's Department of Revenue, and could this situation arise in other states in your expert views?
Yeah, I think that it's not at all uncommon. In fact, I think it's much more common in my experience, having litigated cases across the country, where the Attorney General, whether it's a separate elected official or not, represents the taxing authority. So I think that this could arise, and fortunately, I guess, many state departments of revenue, when they disagree with their Attorney General, find a way to resolve their issues without airing them publicly.
Yeah, that's shocking to read that in this context, and yeah. I know we're just about out of time, and I want to just thank all the panelists who did such a tremendous job today, sharing their insights and differing perspectives on really complicated issues, but all of which really we see how important they are to fundamental taxpayer rights and tax administration. So my hats are off to all of you, and thank you for sharing your thoughts today.
I just want to thank you all. This was really fascinating. The materials that you've given are just really comprehensive. The diversity of issues we discussed are significant. And I think what's really important is not just what Mike said about, you know, paying attention, and Chris, paying attention to state tax issues, which often gets the short shrift because everybody's focusing on federal, but the diversity of the state tax issues is just as Sundar said, you know, having the list of all the taxes in New Jersey that could trip you up. And then the processes that you go through. And then after all of that, then you're like the taxpayer sitting there on the sidelines while this dispute is going up to the Supreme Court. And you still have no decision that's final, which is really interesting and sort of sad. So I just want to thank you.
Can I say something? When you know, Mr. Samus was talking about this case, when I represented Division of Taxation way back, there was a sort of similar conflict. But you know, you're the attorney, the Division of Taxation is the client. And I think for everybody knows it's the client that says yes or no. You can tell the client you're going down a very slippery slope. I don't guarantee you that you're going to win. In fact, I guarantee you're going to lose. And the client says, go fight it. You fight it.
And I've had those discussions actually, and I wanted to hear your point of view there, Judge, because I've had those discussions with people from the Division of Taxation and the New Jersey Attorney General's office. They say, look, we don't agree with this, but guess what? We're gonna present our best argument, and this is the way we're gonna do it. Okay.
Yeah. And there's always a difference. You know, the attorney always tells you, hey, no, this is not a good thing. No, I want this decision. Let the court tell me that I'm wrong. Okay. But you know where I'm coming from. I'll argue it. But so everybody's on the clear, but not this visible disagreement. Yeah.
Well, so now we all can watch out for the decision on that case.
I'll keep you posted. Like I said, I'm checking the docket a few times a day.
Well, if you find out, you can let us know and we'll post it to the materials page so everyone can see that opinion. It will be very, very interesting. So again, thank you all. Thank you for the attendees. This was very detailed, very diverse, but really good background information. We have some really good examples of things that can be identified as best practices going forward as we try to work with states, you know, saying, here's something that's working in one state, you may consider that. So thank you all for all the work that you've done, and thank you attendees for attending, and we will see you next week on Tuesday to talk about collection, which is exciting. So bye now. Okay, bye-bye. Thank you.